All righty, everyone. Well, welcome. Thank you for joining us for the September edition of our community engagement series from the Housing Department of the City of San Jose. We appreciate all of you taking the time to join us today. Today's topic is going to be the Housing Department's Eviction Prevention Program, which has many aspects. And so we have several staff members from the Eviction Prevention Program who are here, who are going to walk through a presentation with you. And then after that presentation is complete, we're going to be taking questions from you about the program. And I would ask that if you have questions, please use the chat function and please send your questions to me, Jeff Scott or Jeffrey Scott in the chat. And I will then be reading off those questions to the entire group, the entire audience, and our staff members will be answering those questions. So again, please use the chat function, send them to me, Jeffrey Scott, the questions, and I will read all of them off. And hopefully we will be able to get through all of your questions. We'll stay here until 4 o'clock, and we're usually able to get through all the questions that are asked. And with that, I'm going to hand over the presentation to Emily Hislop. She is the division manager for the rent stabilization program, which includes the eviction prevention program. All righty, Emily.
Thank you, Jeff. Welcome, everybody. You can put the first slide up. I'm just going to chat a little bit.
All right, give me a second. I'll share screen.
So as Jeff said, I'm the division manager for the rent stabilization and eviction prevention program. And I have here with me today Tu-Yan Tong and Esther Aguirre, who are analysts with the rent stabilization and eviction prevention division that work on our eviction prevention program. Before we begin, I quickly just want to give a little bit of background about how the eviction prevention program, like the origins of how it began. In 2021, as part of the pandemic response, we had eviction moratoriums, as I'm sure many of you remember, and there was a large amount of federal funding that came to the state and to the city to address rental arrearages from the pandemic shutdown. With some of that money, the city launched the Eviction Help Center to connect tenants and landlords to rent relief money, as well as other resources to try and prevent the eviction tsunami everyone anticipated or expected to happen when courts were opened back up and evictions were allowed to be filed. So from late 2021 through early 2023, the Eviction Help Center efforts were the main goal was to get parties connected to the state rent relief program and to prevent tenants from being evicted for non-payment of rent. So we had Eviction Help Center locations, helpline, email. We had locations at City Hall and at various locations at different times. On the east side, where we had multilingual staff that were available to help residents with their eviction and rent relief issues. Around the same time in 2021 fall, we approached the court about having our staff be present during the eviction calendar that could help tenants and landlords right there get access to their rent relief application or start a rent relief application, since that was really the only thing that was going to be able to prevent evictions and get landlords paid back rent. The court welcomed us, and with that partnership, we were able to also establish a weekly UD clinic. UD, we might be throwing this acronym around, is short for unlawful detainer, which is the name of the lawsuit that gets filed with court as part of the eviction process. So we might use unlawful detainer, eviction, or UD kind of interchangeably. So this UD clinic, weekly UD clinic, where we're basically just educating people about the process. Well, I'll let Esther and Tu-Yan talk about it later. It continues to this day at the courthouse once a week. Our staff also continues to partner with the court, day of court mediators, the homelessness prevention system, and attorneys literally in the hallway during the UD calendar 3 days a week to help connect parties to resources that will either keep families housed or provide them with a viable path towards stable housing. So we had council direction during this 2023 period that we should fold some of these prevention efforts into our regular rent stabilization work once the pandemic recovery was over. And so Tu-Yan and Esther will talk about what that program looks like today. So with that, I'm going to turn it over oh, first, let me go over what they're going to talk about. Next slide. So they will give an overview of the eviction prevention program, talk about the unlawful detainer clinic I just mentioned, talk about our very limited eviction diversion and settlement program. That is one of the resources we sometimes are able to offer to people involved in UD action. They'll also talk about our extensive outreach and education in the community, do a quick overview of the tenant protection ordinance, which covers most rental housing units in the city of San Jose. And then also just go over, for those who aren't familiar with, what the eviction process looks like from, first notice to the process it goes to. Okay, so with that, I will turn it over to Tu Yan Tong.
Hi, thanks, Emily. Hello, everyone. My name is Ian Tong. I'm a staff with the eviction prevention. Um, a lot of you might ask, what does the eviction prevention program actually do? We actually run a hotline and email that's available for also housing providers, tenants, and any residents that want to educate themselves regarding their obligations and their rights. We provide information and referrals for both parties that are in this eviction process to legal aid and financial, social services, and housing leakage as well. As Emily mentioned, all of our staff, we attend eviction and unlawful detainer hearings to provide these resources. So we are there in person um, every single day, whether it's rain or shine. Next slide, please. So one of the offerings that we do have at these court hearings and at court is our unlawful detainer eviction clinic. The commissioner introduces us every time there is a hearing and promotes the clinic to all these tenants and landlords and housing providers and attorneys as well. We are located on the third floor of the Superior Court building on Department 6 every single Wednesday from 10 a.m. to 12:45 p.m. We are a collaborative effort with not only the courts, but with the Self-Help Center as well and other agencies. We connect tenants and housing providers with resources before their trial date, also after and during their trial date. We assist these, mainly we also assist with self-represented individuals who are filing with the courts that don't know where in the whole process that they are at. We walk them through and assist them in identifying what next steps they need to take for the eviction process to go smoothly. Next slide, please. So for our eviction diversion and settlement program, as Emily mentioned, it is a very limited program that assists those tenants with those specific circumstances. We mainly focus on those with temporary financial setbacks. One are those when they have a little small hiccup, they couldn't pay that 1 month or two and end up where they're at, but they're picking back up and they're able to pay rent moving forward. Our staff is there every single Wednesday, Thursday, and Friday when there is any unlawful detainer hearings. But for these tenants to qualify for our program, it's a little different. These tenants must be involved in any active unlawful detainer cases. They must have the ability to pay rent moving forward, and they have to earn less than the 50% of the area median income. Our main focus is basically to prevent eviction, of course, and keep these tenants housed. And we also want to assist in these housing providers to recover the costs as well, since this is a very lengthy process. Usually when an individual goes through these eviction process, it do it does take over a month for it to go through. Next slide, please. Our main and number one question when we start these screenings for our eviction diversion and settlement program is consent. Housing providers and tenants must both agree to participate with our program, and it is required that the tenant must remain in the unit. So that's why we kind of promote it as more sustainable and to prevent these evictions from happening. Since our eviction staff work with all parties to resolve these cases, we also get assistance from not only court mediators, but also landlord and tenant attorneys that are present there that day. During those time at the courthouse, Office of Supportive Housing and Sacred Heart is present as well. We get tenants connected to resources when possible and hopefully keep these tenants housed. Next slide, please. Our main goal with this is to promote basically outreach. A lot of people don't know that the eviction prevention program exists, so we are hopefully trying to promote ourselves and educate the community regarding what their rights are, what our ordinances are, and connect basically households to resources to help them prevent these evictions from happening. We're there at our clinic, of course, but we also attend webinars and events. Especially during National Night Out, our staff, we were at several different districts just there and just to promote ourselves. Now I'm going to pass it on to Esther. Esther is going to talk more about what we educate the community about and what the eviction process might look like.
Thanks, Tian. Hi, everyone. My name is Esther. I'm also an analyst with the Rent Stabilization Program and Eviction Prevention Program. I think we can move on to the next slide. So I'll be doing a quick overview of the Tenant Protection Ordinance. So under this Tenant Protection Ordinance, landlords cannot initiate the eviction process without providing notice to the tenant from one of the 13 just causes. And there are 13 specific just causes recognized by the ordinance, such as non-payment of rent, lease violations, or landlord moving into the unit. We'll go over briefly on the next slide. To meet the notice requirements, housing providers must provide written notice to the tenant, and they must also submit a copy to our program, which is the rent stabilization program, within 72 hours. A copy of this notice must be submitted to our team. The preferred method is the notice of termination portal. However, we are able to accept or collect the notification or copy via email or by regular postal mail, and this will help our team confirm compliance. Some of the units covered for the tenant protection ordinance include the buildings with 3 or more apartments, unpermitted units, such as those that are built in garages or converted spaces, and guest house. And then one thing to know is rent restricted affordable housing units are exempt from this requirement. Next slide. And as mentioned briefly in the previous slide, the Tenant Protection Ordinance allows evictions for the 13 just causes. The ones in blue are at-fault reasons, typically non-payment of rent, habitual lease violation, etc. The ones in green are no-fault causes, and those circumstances require housing providers to provide relocation assistance to tenants. Next slide. And this is one of the, if housing providers will be giving notice of issuing a notice of termination, they must serve a written copy to the tenant with the proper amount according to state law. And they must also ensure that at least one of the 13 just causes is noted, and they must also provide a copy of this, which is the resources and referral notice. And these steps must be completed prior to the eviction court case or filing of it. Next slide. And this image is housing providers must provide this tenant protection ordinance required posting to tenants at the time that they may sign the lease, or it must be posted in a common place within the building in a visible area. Next slide. And with this slide, I will be going over briefly the eviction process. So first, the housing provider, as mentioned, must provide required notice to the tenant, which includes the notice of termination and the resource and referral notice form. And then they must also provide a copy within 72 hours to our team. After that, then the tenants would be able to comply or cure it. And if unresolved, then property owners or housing providers would be able to file an unlawful detainer with the Superior Court. And this is where tenants would then respond depending on the action that the tenant takes. Either they respond, which leads to a court date where potentially we can work with some of those mediators or court resources, as Tuyen mentioned previously. If not, if the tenant fails to respond to the unlawful detainer, then it would lead to a default judgment, which will then grant, the court would then grant permission for the sheriff to enforce the eviction. Next slide. And these are some of the resources that our team shares with individuals that call our line. However, some of these, it doesn't list all of the resources. At times, there's specific needs that we might address, but some of them may include Bay Area Legal Aid, Law Foundation, the Self-Help Center, Asian Law Alliance. Next slide. Okay, and then this is just a brief overview of all the different options that residents, housing providers, tenants, community members can connect with us. So as Tuyen mentioned, we do have the Eviction Prevention Program hotline, which is the 408-975-4444. And then we have the rent stabilization program, 408-975-4480. We all work together and we all manage it. So any of those would be like an option for you guys to connect with our team. The RSP general inbox, and then I included the TPO where property owners or housing providers can submit a copy of the notice. And the next slide that Jeff will share is just a quick survey. If you guys have time to provide feedback, it kind of helps our team understand your current knowledge of our ordinances and areas that we could potentially improve or educate. And that will conclude the presentation.
Alrighty. Thank you, all three of you, for sharing that information. Before we start taking questions, and again, if you do have questions for the staff, please use the chat and send your questions to me, Jeffrey Scott, and then I will read off those questions and the staff will answer them. But I know that that the staff just went over a lot of information very quickly in that presentation, and all of you will be receiving in the next few days a link where all of this information will be available. A recording of today's meeting will be available there, as well as the presentation that you just saw that Esther and Tuyen went through, and we'll also have a transcript of the meeting today. So all of those resources will be available on our website, and all of you who registered for the meeting today will receive a link via email where you can access all that, because I know that I know they just went through a lot of information. It might be hard to digest it very quickly. Alrighty, so with that, let me take a look in the chat and see what questions we have, and we'll get going with the Q&A. All right, and Emily, I guess I'll direct them to you, and then you can field them. The first question, Emily, is will we be able to make this program, the eviction prevention program, will we be able to expand it to people in market rate apartments?
Oh, well, I should clarify, the eviction prevention program, we receive a little bit of other funding that's not related to the program. So we serve anybody who is, you don't have to be covered by the tenant protection ordinance or the apartment rent ordinance, but the market rate apartments are covered by the tenant protection ordinance. But we're here to help anybody dealing, with the rental housing eviction.
All righty, then next question is, I'm not quite sure I fully understand it, but maybe you can work through it, Emily. How many families sign up each month or each year in a given period of time? And how many families or individuals are we able to assist?
So we have, I think either Tuyen or Esther can share the numbers of, people who have contacted us, and also who we've screened for that limited eviction diversion and settlement program. But really this is before this program, people who were facing eviction or the threat of eviction, they would have to like navigate this patchwork of resources. So we have the homelessness prevention system. There's other programs out there that have different types of social services. We're really just trying to be a hub of we get people connected to the resources they need. And if we are able to help in some other way, we do. So, Gianna or Esther, did you have any numbers with you? I mean, the number of people that we assist in court and over the phone and person is in the thousands a year.
I don't have the number on the top of my head, but from my experience, I can give an example. Like last week, we had 6 individuals waiting outside of our unlawful detainer clinic just to get assisted. And even this week, we had around 6 to 7 individuals just on a Wednesday. But we do talk to individuals at our court hearings every single week. It just depends on the calendar of how many individuals we talk. But for the phone, we do get a lot of people, as Emily says, within the thousands each year.
And just to follow up, the importance of the clinic is that when a tenant, especially, um, receives an unlawful detainer lawsuit, they have to respond. They have to do a court filing. It's not very straightforward. It's kind of complicated. So the Self-Help Center has materials to kind of walk people through how to prepare it, and the Self-Help Center will help tenants review and get it filed. So at the court clinic, we're able to hand them the packet, also get some information from them, get them connected to resources, explain, like, try to fill this out as best you can, and then you can go over to the Self-Help Center and get some additional help with filing. The other flip side is, say, individual who owns or rents their home is renting out a room to someone, and they want, this is an unrepresented, what would be considered a landlord, individual who may not have the funds to hire an attorney or the wherewithal. The Self-Help Center also has packets for them on how they can initiate the eviction process if they are having an issue with the tenant that they're renting a room to. So we're there to help those individuals. And so I just wanted to explain that it's not that we can just solve evictions, but it's a complicated process, and the outcomes are a lot better if someone is engaged in that process. So we're trying to avoid tenants getting default judgments, which has the sheriff knocking on their door, and then it's a lot harder to get them help before they have to move out.
Alrighty, next question. This person is asking, how do we know our rights in terms of what apartment complexes are legally allowed to do and what they are not? For example, in relation to Section 8 or other programs.
Esther, Tian, do you want to field that question?
Yes, of course. We won't be able to answer that question specifically, but our team recommends residents or households or anyone that has specific questions, they can contact us. We can kind of understand the situation better. If we are able to verify that the unit is covered under one of our ordinances, such as the apartment ordinance or TPO, then we would be able to provide some like action items and fact sheets. If it's not covered and it's something that our team doesn't support, but we have those referrals like we shared, then we can share resources for legal agencies or self-help center. It kind of just depends on the specific thing. But if you have questions, please, we can probably put the slide in a bit back up, and you can contact our RSP at sanjoseca.gov or our general phone line.
All right, yeah, we will try to actually put some of the contact information into the chat in a little bit. All right, next question is when a tenant passes away, how long does the landlord have before they're able to rent the unit to someone else?
That is a very specific question that triggers a lot of other questions that we are not in a position to answer, and suggest there's resources online. The state has a tenant landlord guide, or contacting an attorney, the lawyer referral, the Santa Clara County Bar Association lawyer referral service. that we can put that link in the chat. That's like a low cost for, brief consultation. But that's a very legal question that we can't address.
All right. All right. For people who are able to qualify for the eviction diversion program, which is a type of rental assistance, what is a timeline that people can expect for them to receive assistance, financial assistance, if they qualify?
I'm going to let Esther Tuyen answer this, but I just want to be very specific that the payment goes directly to the landlord. It's not being given to the tenant. Go ahead,
Yeah.
Esther Tuyen.
I think this is very dependent on both the landlord and the tenant on whether they can provide us the documentation, how fast they provided us to us. And it just depends on that. Usually I would say it'd be a week or two. We can notify the tenant whether they qualify for our program or not. That's usually a good amount of time that we can provide. If it's payment wise, then we usually ask up to 30 days, but we're usually very good on time. And then I think that answers it.
Yeah, that was great. Thank you, Tian. All right, let me see the next question. What is the enforcement mechanism for property owners who violate the TPO? For example, what happens if they start the eviction process without stating one of the 13 just causes?
Well, if we receive the notice, because our staff reviews the notices we receive, that if it doesn't state one of those causes, we reach out to the property owner and advise them that they need to renotice. This wouldn't be valid. We're not going to be aware if we don't receive that notice. If a tenant comes to us and has a notice like that, we would offer to reach out to the housing provider to educate them and counsel them about the laws that might apply. We would refer the tenant to legal services. Esther, Tian, do you want to add anything else?
Yeah, I think the biggest thing, like Emily noted, is first receiving the notice. And if we don't have the notice when our team goes to the unlawful detainer calendar Wednesday, Thursday, Friday, we do work with those partner agencies, and we have a pretty good relationship with the attorneys from both sides. So our team is able to verify if a notice was submitted or not. And then we can have conversations and work with mediators to resolve it.
And if it's a willful, like if a property owner is not, if it falls under a tenant protection ordinance and they're not willing to comply, we do have some enforcement mechanisms in our ordinance. We would issue a notice of violation and correction. We have to collect enough evidence, and it could lead to an eventual citation if it reached that threshold.
Alrighty, and a reminder, if you have questions, please put them in the chat to me, Jeffrey Scott, and I'll read them off. All right, our next question is pretty lengthy, so I'm just going to read the entire thing here instead of trying to paraphrase it. Months ago, the City Council voted to hire a consultancy firm to study the possibility of funding the right to counsel, meaning legal counsel, free legal representation for low-income renters facing eviction. When is a report from this study expected to be presented to the City Council? That's one question. When will the report be presented? Then the second part of this is, and what do the lawyers who are in the hallways during the UD clinics currently do for tenants?
Okay, I will answer the first part. So we did engage a consultant to conduct a study on eviction court interventions. That does include right to counsel as a possible intervention. That report is being finalized, and it will likely be announced to council through an informational memo this fall. And regarding lawyers in the hallway, most of them are landlord attorneys, but Esther Tuyen, if you want to speak to your experience on the ground.
Yeah. So there are self-represented landlords and tenants, but there are also individuals that are represented. So those attorneys there are just they help filter out the conversation. Usually there are mediators there too that work with these attorneys that assist in having them settle on something that seems probable for each tenant and landlord.
All right, great. And then there was another question also about the timing of that report to the city council, and I think Emily's answered that. Okay, next question. Is the self-help center funded by the city of San Jose, and or should we only encourage San Jose residents to go there, or can any Santa Clara County resident seek help there?
The Santa Clara County Superior Court Self-Help Center is not funded by us. It is funded by the courts. It's a program there, so I don't know what kind of county funding the courts may have, and it's open to all Santa Clara County residents. The in-person services are only for emergency filings, which are limited, and but they do consider a tenant filing an answer to an unlawful detainer and emergency filing. Self-help center is available for other. We have the website on the slides. We can put it in the chat. They're available to assist via live chat or via email or phone if you fill out a form.
Okay, next question is about tenants who try to go back for assistance multiple times. Like if a tenant seeks financial assistance, every few months or on multiple occasions, are they allowed to do that, or is a tenant able to come back to that eviction diversion and settlement program multiple times?
Suya and Esther, I'll let you guys answer that.
Yeah, of course. Our program is a one-time only program. It's just a little small program that helps when you're in a little small hiccup. So we hope that the individual never ends up back in that same position ever again. So that's why it's only a one-time assistance. We also do feedback surveys for those tenants and landlords as well. So after every 3 months, we give them a call back just to see where they're at in their position, and our program is ever changing.
Okay, there's another question. I'm just going to quickly address this. There's a question that's kind of a little off topic here. It's about uh, people seeking affordable housing, maybe people moving into the area or people who already live here seeking affordable housing. And I'll just say that we have an affordable housing portal. We can put that link in the chat as well. So anyone who's looking for affordable housing in the city of San Jose can go to the affordable housing portal to see what vacancies exist and what properties may have wait lists that are open. So we'll put that link in the chat for you. All right. Here's next question. Again, maybe I don't quite understand the language, but hopefully maybe Emily, you can sort it out. Is there anything that we can do as HPS case managers to further assist clients and tenants who have already received their notice to vacate from the sheriff?
Oh. So the notice to vacate is the step after, so there's been a court judgment. The landlord got what's called a writ of execution. They brought it to the sheriff and the sheriff posts a notice to vacate. The tenant is entitled to stay up to 40 days if they deposit with the court a per diem rent amount for the time that they're staying, but it has to start from the date of judgment. So that buys some time, but they have to do the filing. It's called a stay of execution. The self-help center will assist with that. But so that's kind of like the most viable thing that a tenant could do, but that would just buy them time. Trying to get the judgment set aside is a more challenging process. It can be done, but you need some legal help with that, and you have to have an acceptable reason for the judgment being entered if it was a default judgment.
I was going to add to this as well. Our team does work with the homeless prevention system. They are one of the Sacred Heart goes to court. So if you are a provider, that make sure you connect with the network, and then we can kind of see what other resources can be provided.
All right, moving along here. Next question. This comes from someone who's asking on behalf of case managers who work with clients who have developmental disabilities, or people who advocate for people with developmental disabilities. And they're asking if we have a point of contact in the housing department here, Emily, for people who are advocating on behalf of those with developmental disabilities.
Esther, do you want to? Is that for assistant? Well, you can speak to connecting with other groups.
Yeah, specifically they're saying how can I'll just again I'll just read it. How can our I lost it. How can our case managers tap into the eviction payment program on behalf of our clients with developmental disabilities?
Yeah, so it's margin. If there's any questions, a case manager could connect with someone from our team utilizing the eviction help email inbox, and then we can kind of filter through and walk and see if we can assess or provide guidance on that specific one. But we do get some communication that way. Or if you are tied to the homeless prevention system, then the network also communicates with us.
Our next question, and maybe I think we touched on this in your slides, Tuyan and Esther, but maybe you can reiterate this. Next person is asking who does not qualify for the EDSP program, and I know you talked about the qualifications or what you screened for. Maybe you can just reiterate that.
Yeah, of course. I think first and foremost, we do have a preference for those that are under that 50% AAMI. It has to be consented from both the housing providers and tenant side, just for them to stay in that unit. As well as I believe first and foremost, unfortunately, this is only offered for the city of San Jose. So it has to be a city of San Jose resident. I believe there was one more point on the slide, but it has to be
That
that
they
they have
can
to
be
live,
able to pay going forward.
yeah, they have to sustain that area for up to a certain amount of time.
And I just, because there's a lot of questions about our eviction diversion program, this is very, very, very limited. We help maybe 100 households a year. This is not a rental assistance program. This is not something people could call and get access to. We don't have very much funding, and it's very specific. And we've done a lot of work to call back all of our participants in this program and called their property managers, property owners to find out, is the tenant still in the unit? Are they paying rent on time? To really refine, to make sure we are helping the people who we don't want to replace the homelessness prevention system. We are trying to kind of fill this other spot of, people have a high rent burden. It just takes one little thing to get them to fall behind and possibly be facing eviction. We'd love to get to them further upstream. We're working on that. But so I don't want people to walk away from this thinking, oh, you can call for rental assistance. That's just going to lead to a lot of disappointed people and a lot of tired staff who don't want to disappoint anybody.
Thanks. And I am just so you know, I'm seeing some questions here that are very specific, very individual, speaking about specific landlords or specific tenants. And that's, of course, not what we're here to discuss. We're here to discuss the eviction prevention program more broadly. So I would encourage you, if you have a specific question about a landlord or about a tenant, to please reach out to the eviction program, the staff, make a phone call or an email inquiry to the staff and talk with them directly offline. During this public meeting, we're not going to be talking about individual tenants or individual landlord situations. All right, next question. Okay, this probably gets into the 13 just causes. if a tenant has a pet in their apartment and the pet is not allowed, um, what recourse does the landlord have, and are there exceptions for service animals?
Part of it is a TPO that fits, there's a clause in the lease that they're not allowed, then the process that if this is a unit covered by the tenant protection ordinance, you have to give a notice to the tenants before the opportunity to cure. We do have if it's covered by our ARO property, we do have a joint petition process where there can be a small bump in rent to accommodate a pet. I just want to put that out there because we're all for tenants and landlords sorting things out without going to adversarial. We can't, the question about service animals is a fair housing legal question. I would suggest one of our service providers, Project Sentinel, does fair housing education for landlords and tenants on just those issues. Their website is housing.org, and they would be better equipped to give you counseling on that particular question.
And then we have a question about the 50% AMI, area median income requirement, that has been mentioned a few times. Just to clarify, is this as you're screening potential tenants for this program, is it a requirement or a preference that they are under the 50% AMI, the tenant income?
Esther or Tian?
Yeah, a priority will be for households with AMI below 50%. We would consider other ones, but again, the screening process differs and we would have to assess it.
There's special circumstances, but I think our top limit is 80%, which is considered low income. And that's only in very specific circumstances.
All right, I'm just going through. I am just going through to see if I missed any questions or not. We've gone through a lot. Okay, I think there's another question here. One person is asking why housing providers have to go through the steps of the unlawful detainer process, including the tenant protection ordinance, before filing their unlawful detainer case with the court, and they're asking why they have to do that.
That's state and local law. So the eviction process is governed by the state, and even the state has just cause protections for tenancies over 12 months. So in addition to us, but it's a tenant can't pay rent, you've got to give that notice to pay. That's state law. Oh, you're on mute, Jeff.
All right. Yeah, I think that is it. I'm not seeing any other questions. So I just want to reiterate that everybody who registered for this meeting today is going to receive an email from us in the next few days, and it will have that presentation that Tu Yen and Esther went through. It will have a recording of this, and it will also have a transcript of this meeting as well. And if you know anyone who wanted to call in or participate today and was unable to, please feel free to, excuse me, share that link when I send it out to you by email. We want to make sure that all the resources are available to as many people as possible. And I believe Esther has also, just in the chat to everyone, she's put an email address and a phone number in there. If you have those questions that I mentioned before, individual questions about a landlord or a tenant situation, that's the email address and the phone number that you can contact to have your specific individual questions answered by our staff. And that's it. I think we went through all the questions. So again, thank you everybody for joining. I appreciate it. And thank you to Yen, Esther, and Emily for hosting. Thank you very much.
Thank you.